All right, everybody, thank you very much for coming to our monthly meeting and Judge Jennemann's State of the District Address. We're going to go ahead and just get right into it. There is CLE credit available for this presentation. For those watching this on video, we'll give you that number at the end of the presentation. For everybody that's here present, I printed out the course number and information, and there's a pile of papers on the desk. We're going to have Judge Jennemann speak to us, and then she's invited us to, upon the conclusion of her address, raise any issues, comments, concerns we have regarding bankruptcy practice in the Middle District of Florida. So please, if you have anything on your mind, this is your opportunity, so I encourage you to take it. After that, Judge Delana will come up and say a few words. So without further ado, Chief Judge Jennemann.
Well, do you feel a part of the district yet? I hope you do, because over the last few years, this is my third or fourth time I've been down to give you my thoughts on the district. This year, my topic is going to be called #technology, and that's because my husband and I, over the last year, he's a solo practitioner, he works out of the house, and he had to upgrade all of his computer and software this year, and there were a lot of words coming out of his office that I can't repeat here. And in order to sort of diffuse those bombs, we put down a word that whenever you're frustrated with technology or software or a new computer, you have to say #technology. And we've been saying that a whole lot this year. And as I prepared my comments for today, I realized how much of the progress we've made throughout the district during the last year has been due to technology. Justice Roberts, in his annual State of the District, noticed the same thing and commented about how the courts as a whole are usually pretty slow adopters of new technology because our tent's really big. We have about 20% of the bankruptcy group is pro se, many of whom don't have email or computers or access to them. And then we have the gigantic firms, national firms, that are much more sophisticated than anything I'll understand. So we have a big tent, we have to make sure everyone's included, and we're often slow in making changes. But I will say the bankruptcy community as a whole has really embraced technology because we've had to. Over the last few years, we've had such a reduction in our staff, and because of that, we've had to rely more and more on both technology and your efforts. So as I go through the comments today, I wanted to say that much of it is due to technology from the progress we've made the last year, and I will tell you that the changes to come are going to be driven by technology changes. But first, just the basic statistics. Most of you know much better than I that the economy is rebounding, that home prices are up roughly 23% statewide, the capital markets are flowing, and that banks are getting much more sophisticated about workouts or shedding debt that they no longer want to maintain. So the industry is more sophisticated and bankruptcies are falling. They've fallen about 12% every year for the last 3 years. We ended 2014 with roughly 36,000 cases district-wide, down from a high of almost 67,000 cases. So you can see the progressive downward trend. In Fort Myers, the case filings went from 3,101 to 2,491. Very consistent percentages, and you're seeing exactly what we're seeing district-wide. We, however, are still the third busiest court in the country. We follow only LA and Chicago. We are the second busiest in business filings, which includes Chapter 7 business filings. We're fourth in Chapter 11s. So it is startling when you think of the colleagues that you have across the country, what they must be suffering if we are this busy and you can still see the reduction in our case filings. So we are keeping on. We've always been a busy court, and we handle our workload through the help of talented jurists, my colleagues, as well as talented lawyers, and the help of bar associations like this association. So I did want to announce one sort of exciting new program we're going to participate in 2015. It's called the Bankruptcy Judge Pilot Project, and you may have heard some rumors about it, but we're going to get a new bankruptcy judge in the Middle District. The judge is going to be appointed by South Dakota from the 8th Circuit. South Dakota has had 2 bankruptcy positions since 1993. They've never filled the second one. The one judge that sits in South Dakota has a weighted caseload of about 100. I have a weighted caseload of about 2,500. So you can see that they don't have an anticipated need for a second bankruptcy judge. So there's going to be a memorandum of understanding between the 11th Circuit and the 8th Circuit, and the judge will be appointed to sit in the Orlando division, only because that's where we have courtroom and chamber space. But the judge will work throughout the district, and we don't know what case allocations will happen until the judge is here, because we don't know when that will be. But you can anticipate we'll welcome a new judge this year, and it will be a creative project. It's a regular 14-year term. It'll have a national notice, and that will happen as soon as all of the details get worked out, which I don't know exactly when that will be. So we are excited about that. I want to compliment all of the bar associations, all the attorneys that have been so kind to our staff. As I said, we've seen a huge staff reduction, 27% over the last 3 years, and that's caused a lot of extra stress on our personnel. We work with a total force of 86 people, down from roughly 130 for the whole district. And so we are very stretched, very thin, but almost weekly I get thank yous and compliments from either litigants or from bar members or staff at attorneys' offices, thanking a particular case manager for something they've done good. And if there's anything I can encourage you to do, it would be that. These people are so appreciative of when anybody recognizes that they did something good. I bet most of you would like to get compliments for your work too. And so they really do appreciate it, and so keep those kinds of thank yous coming, and we're very proud of them. Over in my last few State of the District speeches, I've talked about where we're going and how we're working towards being one district, not 4 divisions, where we're trying to uniform our procedures and practices and get on the same page. And I can tell you that the last 2 or 3 years have been working through the processes, but during 2014, we got there. We set a goal, and now we are essentially there. And I cannot thank my colleagues more for all of the work they did to get us there. We couldn't have done it without your help, and we couldn't have done it without technology. One thing I wanted to give a shout out of accolades is our website. It's one example of how we're trying to get on the same page, is make that the place where people look to see what the uniform procedures and practices are, and we're still in process. But this year our website got recognized as one of the 10 best in the country. It's the only federal court that was recognized by the Forum on the Advancement of Court Technologies for that recognition. And we are thankful to our website committee and to Sarah Weiner, who is our chair of that committee, for keeping it and making it such a good product. But we want to continue to improve it. One thing that you'll see is some changes over the years. So when you have trouble finding something, let Sarah know, because that's what we need to know, your input. We're working primarily on the internal side this year, but we will continue to improve the external website when we can. We've also had to do a lot of our docketing automatically, and this probably doesn't affect you because you don't notice how the docketing occurs from our side. But right now, roughly 25% of the docketing that we do is automatic. That means nobody touches it. Nobody makes a keystroke. It's when you file certain things, if everything is correctly filed, it automatically is a docketed entry, and that's 25% of what we do. But we can only do those sorts of automatic entries if all of the divisions handle things the same way. And so by the percentage you can tell of the automatic docketing, you can see we are getting there. We have 36 posted internal procedures that are huge. For example, one is how we open cases. That's every case. All 36,000 cases are now open the same. They're all closed the same. Discharges are entered the same. And many procedures that you never see are now the same district-wide. For example, how we tell you you made a mistake and need to fix it. That's all the same. There's many of these things that have now gotten to be uniform. And eventually we got to the harder ones. And this is the year we hit the judicial level of discussion. And the shout I want to give out to the folks here that have served on the steering committee. We've had Richard Johnston, Bob Tardif. Oh, I'm going to miss people, and I'm sorry I don't have all the list in front of me, but the district-wide steering committee has been phenomenally helpful to the judges. The steering committee is a group of attorneys and other constituencies represented that give us suggestions. It's across the district, across types of practices, and they meet roughly once a month by video and then come up with, through subcommittee work, suggestions. One of the biggest suggestions they raised to us this year were how we handle adversary proceedings. And because of their suggestions, and the judges received them, we debated them over several months. And my colleagues have learned that we can truly express our opinions, strenuously sometimes, and debate issues, but yet at the end of the day, compromise on what we all think is most important, which is to have one standard. And because I'm sure many of you have been in groups where everyone sits around, everybody says, oh, that sounds good, and then everybody goes back and does whatever they want to do. And if we did that, we would be in big trouble right now. But I can tell you that my colleagues are now on board with when we decide, they will follow the rules. And on December the 18th of this year, of 2014, I issued the administrative order on adversary proceedings. We did it as an administrative order because we want to, quote, test drive the procedures to make sure that they meet our needs and that they meet your needs. So we're certainly welcome for suggestions on revisions and improvements, but starting February 1st, for every adversary proceeding that's filed in the district, the new rules will apply. And I'm just going to touch, please read that if you file an adversary proceeding. Read it before you file the adversary proceeding so you can follow them. But essentially, know that there's a 30, 60, and 90-day window. The 30-day window is when you must serve the complaint by. And you must serve both the complaint and this new adversary order so that everybody gets notice of the new rules. At 60 days, we look at it, and that's the deadline for you to file a default or anything to move it along. At 90 days, you'll have your first pretrial conference. If you do not serve the complaint timely, it's likely that adversary proceeding will be dismissed without any further hearing. So please know that you need to do that. We're also going to monitor at the initial pretrial conference agreements that we hope that you reach at the initial meeting of parties. That's where, pursuant to Rule of Civil Procedure 26F, you all get together and talk about the case, perhaps a joint discovery plan or other things. So please know that we are going to ask those questions starting at the pretrial conference. The other big change that you may see is that all motions in adversary proceedings will now be done by negative notice. This will force a response if you oppose the motion. And you will have 14 days to respond, 7 days for a reply period. I think you can still pretty much bet that in this division that will still be set for oral argument in connection with the pretrial conferences. But not all divisions will set those hearings. So make your best arguments in the papers. If it's uncontested, submit an order. It'll be entered before the pretrial conference. So that's a sort of a big change, but it's one we thought was fair. It helps us prepare for pretrial conferences. It helps people state their position and discuss it between themselves before the pretrial conferences. So we're really excited about that. And we know it puts a little burden on you, but you're going to have to come up with it anyway. So let us know what your position is in response to these negative notice motions. A couple other dates, trial dates will be set, and then look at the administrative order, but you have to do things 28 days prior to trial, 14 days prior to trial, and then 7 days prior to trial is the date you have to exchange exhibits and to complete discovery. So it's going to be standard district-wide. And Other than that, there's a bunch of other little things buried in there, but I just encourage you to read the administrative order. Judge Delano has done a superb job of chairing the local rules committee, and we've made a number of changes that were effective July 1. But in connection with litigation, one thing I wanted to mention was the new 2004-1 rule that makes it easier to get 2004 exams without court order. You can simply notice them, docket the notice on the court's docket, and if a party does not file a motion for protective order, you go ahead and have your exam without order. This year, the Rules Committee is going to make a number of other amendments, but they are going to do review and edit of all the rules they haven't yet touched, many of which need to simply go away because they're outdated, they are no longer needed. So you will see by the end of this next year, by July 1 of 2015, in all likelihood, a totally redone rules body. I will say most of the big rules have already been addressed, so there are some changes that you can anticipate, but mostly it's just going to be a cleanup and edit year. Another administrative order that we entered in connection with litigation issues is addressing electronic exhibits, and that's 2014-6. But we are going to move towards only electronic exhibits. We're not there yet. Again, we're test driving the concept. But if you have 25 or fewer exhibits, just file them on the docket before the hearing. If you have more than that, bring them on a flash drive or or CD or whatever media you prefer. Because in the future, we're going to keep all exhibits on the docket in electronic format. It helps us. We don't have to store them. We don't have to move them. We don't have to organize them, nor do you. When you share exhibits, they're right there. If there's an appeal, it's just a click of the button. So we are going towards that. Judge Williamson had already adopted that procedure, and this is largely his suggestion. But he used this concept in a recent 2-week trial that he had. And during the trial, people did bring small binders of relevant exhibits by witnesses in paper form that they used during the witness testimony. You're welcome to use whatever existing electronic technology we have in our courtroom. Some have more, some have less. But you can also bring paper with you if that's what makes you comfortable. The difference is we're going to throw it away after the trial, or you can take it back. We will not need to keep it, and we will be, as I said, converting to totally electronic exhibits over the next year. We hope that makes it simpler for everybody. This year we also completed what I call the 3 boxes. We already had finished pretty much the negative notice box. That's things that you knew to notice by negative notice. And everybody across the district has been following that now for a couple of years. But what we hadn't defined is what to put in the other 2 boxes. What do we set for hearing? And what do you just submit an order with? And this year we finalized that. And I will tell you, this is a good example of how the judges are now working together. We meet 3 or 4 times a year in person, and at this particular meeting in May, we sat around the pool, and I literally had a box of all of these items. Which one do we do, hearing or no hearing? And we pulled them out over cigars around the pool, and decided that this goes in this one or this goes out. So now we have an accompanying motion list. So I hope your staff is using that as a tool to let them know when to submit an order, when or what will be set for hearing. And of course, we will continue to set for hearing. One advantage or one perk the trustees got this year was to self-calendar. We're glad we were able to do that for the trustees because in 2013, we started requiring you to serve orders. 2014, you started noticing hearings. Self-calendaring helps the trustees to some extent. We know we've put a lot of burden on the bar. We know that, but we can't do it anymore. So we hope that some of these tools help you. For example, the accompanying motion list will help you streamline when to get us orders and process them. That's our goal. In August, we issued new district-wide reaffirmation procedures, and it's very simple. We use the national form. We have uniform practices of setting hearings. We always had set hearings on pro se reaffirmation agreements, but now we will set them if the attorney has not signed the reaffirmation agreement, or if the attorney notes an undue hardship on the reaffirmation agreement. And my only comment on those procedures they're very simple, but is make sure that the agreement is reached before the discharge is issued, or if you need more time, ask before the discharge is issued. Because I think as a rule, you will not get it vacated to allow a post-discharge reaffirmation. We issued district-wide procedures on stay, really from the automatic stay, and those have almost been seamless, but we went from literally 12 processes to one, and it's set forth in the new local rule 4001-1, and it seems to be working. We've had no problems with that, although if we need to improve them, again, let me or the steering committee know. The mortgage modification mediation procedures were made uniform this year across not just our district, but across the Southern District and the Northern District. We now have one statewide process that is used for all mediations to modify real estate loans of any type in any chapter. And I just codified those in administrative order that I just did issue because people were having trouble finding where those rules were. So that just did go out in 2014-9 administrative order. I don't think there's anything surprising. It requires the use of the portal, and that seems to be helping. But again, the steering committee will give us any suggestions, inputs, improvements that they suggest. And I know I'm harping on the steering committee, but I cannot stress to you how much we look to that body to help us in this process of district-wide uniformity. On November 5th, they held their benchmark conference, and they talked about 3 basic topics. And you can bet that those 3 topics are what we're going to address during the coming months. One thing they discussed was how to improve the mortgage modification mediation procedures, and we'll get that report soon. That's going to be the first thing we're going to hear. Next, they talked about the problems with student loans and the bubble that's out there, and the tremendous amount of student loan debt that is non-dischargeable, and it is a huge problem. Unfortunately, there were not many ideas from a judiciary perspective we can help those parties with. If there are, the steering committee will raise them to us, but it is just a sad problem from everybody's perspective. It is, except through litigating individual cases or other aspects, legislative change perhaps, it is the biggest problem I'm aware of with no solution. But at least there was somebody that, I will tell you from a judge's perspective, we are very sympathetic. It is the type of case, 523AA cases are our least favorite things that we do. They're horrible. These people come to us with absolutely nothing, but they're not, usually fail to meet the Bruner test, and it's just sad. So we talked about it. Maybe something will happen. I don't know what that something will be, but that was the second topic discussed at the benchmark conference. The last issue were Chapter 13 issues, and that is where I think we will spend most of our time from the judge's side this year. We have a number of problems with homeowners association issues, surrender of real property issues. We have problems with different processes among the judges, and our Chapter 13 trustees have been working together closely. John Waggy and his protege, who's the new Chapter 13 trustee, Kelly Remick in Tampa, as well as Lori Weatherford in Orlando and Doug Nieway in Jacksonville, have been working together really closely. And they have already proposed one common debtor duty order that would be applicable to all Chapter 13 cases in the district. The judges are going to debate those issues on February 27th. I think they will go through, I think we'll probably either finish or almost finish the discussion during that meeting. And so soon, during the course of the year, you're going to see a standard Chapter 13 initial debtor duty order, as well as a uniform confirmation order. I have no bets on whether we'll see a national plan or not. I think it's likely you'll see a preferred model plan for this district, even if there is not a national plan. So most of this year is going to be encompassed with us fine-tuning our Chapter 13 procedures and working through that process. So if you are a Chapter 13 practitioner, get to know the people on the steering committee, get to know your 13 trustee, as I'm sure you already do. But, you know, any thoughts or suggestions, this is the time to start thinking about raising those. As I said earlier during my presentation, we couldn't have made all of these advancements without both your assistance, your thoughts, your ideas, but also your efforts on both the noticing and service of orders. And I wanted to give you a couple things that we hope will help everyone in reducing your staff time and the cost to you. One is the debtor noticing project. Nationwide, our noticing center, Bankruptcy Noticing Center, is going to permit electronic notice to debtors. That is only going to be for court notices, but like our 341s and such will now go to debtors who consent electronically. We're going to piggyback that within our district so that if your debtors will consent to electronic notice, then anybody that serves anything in that case will serve it electronically to the debtors. What we are finding is that so much of the service is only to debtors' counsel and to the debtor, or other creditors who want electronic or have already consented to electronic notice, that if we can get the debtors on board, so much of the noticing and service costs will be saved. So we're going to roll those procedures out probably mid-year, because it's going to take us a while. But what we hope is that soon that the only parties you'll serve by mail are the unusual orders or that sort of thing, to hope keep the costs down. And the other big project, which I think you'll see the benefit of very, very quickly in April likely, is our e-orders program. Right now, there are all different ways that you submit orders. Now, luckily in this division, you only have one judge, and so this is not so much a problem for you guys. But come April or so, everyone in the district will submit their orders via CMECF. It won't be this sort of cumbersome process we currently have. And you'll be able to track the orders upon submission. It will be very seamless to the way you would file a motion. You'll submit a proposed order. And so from your perspective, I think you'll see a great benefit in simplicity, and you'll be able to see that the order was received. If it's rejected, it will be very easy to see why. It'll be easy to resubmit, and it'll accomplish a lot of your concerns. And we do this because we really do take our court mission seriously. We ask you to do a lot, but we also try to live up to our mission, which is to serve the public by processing and deciding bankruptcy cases with fairness, impartiality, and excellence, while treating everyone with dignity, integrity, and respect. And we really genuinely mean that. Some other challenges you're going to see this year, and one is I can't underestimate that this is going to be a challenge for you. CMECF was a program that was implemented by us in 2003-04. And it was a huge transition when we all went to electronic filing. And I don't know if those of you who remember those days of going from paper filings to electronic filings, but it was a great challenge. Well, CMECF as a system has gotten a little clunky. And so over the course of the next year, certainly by the end of this year, by December 15, we're going to have to convert to the next version of CMECF, which is called Next Generation. They tell me it's substantially different. They haven't given us any training, and we don't know what to expect other than some of the early pilot courts have said, be ready for Next Gen. So we will be implementing it. We will have no choice. We have no choice. We are on the national platform. We will impose that on you. We will provide as much training as we can. We are going to have problems just like you, but you will have problems. And we're going to have to work through those. So when I say hashtag technology, that's one of the ones you'll be hearing a lot. As we make all these transitions, we still have a couple of challenges that your bar particularly is working to solve. One is, how do we address the needs of the pro se parties? And I understand, you're working with Avi Maria and the local legal aids clinic, and Paul was bringing me up to speed that that's really moving along. I know this is a bar without a resident judge, and that this is a big challenge for you, and we cannot tell you how appreciative that you all are working on that project, that you're now part of BLESS, which is the Bankruptcy Legal Educational Series, Inc. and that it's all working on a forward path. In, I want to say October, Bless received funding from the Benchmark Fund, which was a huge recognition by the district court of the work that the bankruptcy attorneys are doing. They've never given an award of $22,000 to anybody before. So it's really, they know that you all are working hard, and we, on behalf of the judges, appreciate everything you do to help our pro se population. I also wanted to raise just one little tweak that we've seen more than we've ever seen before, and that is, what do you do with parties that were represented, but then the attorney is disbarred, suspended, dies sadly, becomes disabled for whatever reason, and it is not the court's problem. We don't tell people who to pick for lawyers, and we don't want to pick up the pieces when a lawyer goes. That's not our job. But we would love to have some system to let at least the bar know that there's something out there. In Florida, you're supposed to have an inventory lawyer. We're finding that a lot of lawyers don't. And it's just a really sad problem to have when you have people whose rights really are being very significantly prejudiced because of the lawyer going away. So we're going to work through that through this next coming year. But mostly, we're going to just continue working on the goals of working towards uniformity and using technology to improve our services to you. We are trying to predict what's going to be coming in the future. I think you'll see our staff having more flexible hours, more telework. We find teleworking promotes both accuracy and productivity so much that we're encouraging it. We're transferring from little cubicles to more open workspace to encourage people to work at home some, and that has really helped us. So that's sort of our year in the past and our year to come. I can't tell you how appreciative I am for the opportunity to talk to each of you guys and to highlight what we've done. And don't forget, even though technology brings pain, it also brings gain. So we're going to get there together. I'm going to get Judge Delana to go ahead and give me her comments, but usually I meet with the leaders of the bar for just a little. Every one of you are leaders of the bar. If you're here, you're a leader of the bar. So after Judge Delano is finished with her thoughts, then she and I are both going to stick around for anybody that wants to stay, that has any questions, has any concern, want to have a discussion. We would love to hear your comments. So, Judge Delano.
And before Judge Delano comes up, I wanted to apologize. I forgot to welcome Leanne Bennett, the clerk of the Bankruptcy Court,
And if you haven't met Leanne,
to the meeting today. She's here. Gentlemen, she's not going to make any formal presentation, but if anybody has any questions for her, she's here at your disposal. The CLE number for the presentation is 1409151N, and papers are on the desk. Judge Delana, all yours.
I'm always so happy when Judge Jennemann comes down to Fort Myers because I get the chance to see her talking to Fort Myers attorneys and to demonstrate what I have been telling her, who do demonstrate what I have been telling her over the last 2.5 years since I've been coming here, which is what a wonderful bar the Fort Myers bar is. Just a great group of lawyers, great group of practitioners. Those of you who are here today are the lawyers that I see month in, month out. But I see all the time, and it's really great to have you all here, and I'm so glad that you get the chance to talk to Judge Jennemann as well. I want to talk for a moment about Judge Jennemann, and she's going to get mad at me when I say this, but she talked at the beginning of her presentation today about Chief Justice Roberts' State of the Court address that he gives as a report that he does every year. I think it really goes to Congress, but it's published. And one of the things that Chief Justice Roberts said in that report this year was that the judiciary moves slowly. And as a member of the judiciary, I can tell you the judiciary moves really slowly. And the reason why we've been able to accomplish as much as we've been able to accomplish over the course of the last several years is because of Judge Jennemann's efforts. She's been very proactive, she's really been a visionary, and she's brought us all to the table in ways that probably you all would not realize have been as as difficult as they may have been sometimes. Because you have judges, you know, I'm the newest judge on the bench, but you know, judges who've been around a while and they've been doing things the way they've been doing them, and their staff has been doing them the way they've been doing them, and they're not really inclined to change. And it takes a great deal of diplomacy and interpersonal relationship working to make these all work. Now, you all that are in Fort Myers, some of you practice only in Fort Myers. And so you may be saying to yourself, well, that's really great that the district is working on these district-wide uniform procedures, but what difference does it make to me? It doesn't really impact on my life. For many years, I practiced before Judge Pasquet. Judge Pasquet did it his way, and as long as I knew what his way was, everything was great. And you've had to make a few adjustments over the last few years as different judges have come into the Fort Myers division. But you know, what difference does it make to you that things are done uniformly on a district-wide basis? And I'm here to tell you it makes a huge difference to you. And that is because of what I will call the iceberg. The work that the lawyers do is the tip of the iceberg. And you don't realize, and I didn't realize until I became a judge and went to work with the court, how much work is being done below the surface. So a lot of work is being done below the surface. A lot of everything that you do is being touched by a number of different people. And we have case managers in Tampa, we have case managers in Orlando, case managers in Jacksonville, and as you all probably know, they used to be divided up on teams, and each judge had his or her own team of case managers. Well, those case managers knew how their judge did things, okay, knew what the procedures were for that judge. Well, you might have a team, let's say, I think in the glory days, the teams were 10 or 12 case managers. Now we don't have teams anymore, but they were down to the point of about 5 or 6. So you had 10 or 12 case managers working for a specific judge. Well, let's say in any given month, one case manager was out on maternity leave. 2 case managers went on vacation. Another case manager suddenly got sick, and another case manager had a death in the family. Suddenly, the workload that was being done by 10 or 12 people was now being done by 5 or 6 people. And when those teams got reduced to 5 or 6 case managers, suddenly instead of having 6 people available to handle one judge's cases, you were down to 2 people. Well, and the problem was there was no ability to transfer work to the members of another team. The way that the teams are set up now, and I keep using that word, but they're not teams, they're really just by divisions. With the divisions all handling cases the same way, a case manager in Jacksonville can work on a Fort Myers case. And it just processes the work so much more quickly than what it would be, what it was capable of being processed under the old system. So it really does make a difference to you. The other thing that I think is helpful is that as we've gone through this process, a lot of thought is being given to our procedures, and we're kind of streamlining a lot of the procedures, and I think that's beneficial to you as well. Judge Jennemann mentioned that we'll be having another local rules initiative this year, and this year is primarily a cleanup year. The revisions will be posted for public comment on March 1st, and I hope that you all will take a look at that. I did want to say just a couple words about some upcoming programs. Unfortunately, they're in Tampa and they're not in Fort Myers, and I know that it's a long drive, so you can feel my pain if you drive up to Tampa for these programs. But on Friday, February 6th, there's going to be a Chapter 13 boot camp. Kelly Remick and John Waggy will be featured speakers during the program. And some of you do mortgage modification mediations. I don't know if all of you do, but I'm telling you, you all want to come to the lunch program because Igor Reitberg, who is the developer of the portal, is going to be speaking to us at lunch. He came and spoke to us at a judges meeting, I think it was this last summer, and I'm telling you, we were blown away. I thought that the portal was kind of like the cloud, and you uploaded things to the cloud, and as long as you had a password, you could see what was posted. But the portal really is a case management system for mortgage modification mediations. If you're using the portal already, you know how it works. If you're not using the portal, you don't know how it works, you will be blown away. And I really would recommend that you come up for this program and get the opportunity to see how the portal is working. There's a tremendous opportunity right now to work out these mortgage modification mediations. And if your practice includes it now, that's great. If it doesn't, this is really an opportunity to get some education on how that mediation process works. Also, the annual ABI Pasquet seminar is scheduled March 5th, 6th, and 7th. That will be at the Tampa Hilton, which is the old downtown Hyatt Regency Hotel. Many participants in the panel discussions are from Fort Myers. Some of the topics that are going to be covered are trial preparation, appeals, and case law update. Judge Steele is coming to present on a panel of district court judges, along with 11th Circuit Judge Wilson on bankruptcy appeals. So I think that will be very interesting. Other practitioners that are coming up from Fort Myers and participating in panels include Luis Rivera, Paul Giordano, Kelly Remick, Tracy Stevenson, who, as you all probably know, does a lot of the mortgage modifications, is going to be speaking on mortgage modification mediation, and so that probably will be helpful as well. It's an expensive program to come to, and I realize that, but it's 13 and a half CLE hours, so it's really a great bargain, and plus an hour of ethics credit if you go to the entire program. So I really would recommend that you all do that. All of you are active within this community. I can't tell you how much I appreciate the work that those of you who have worked district-wide have contributed to the processes that Judge Jennemann has been talking about. And I'm going to skip over names, I know, but Greg Champeau, Richard Johnston, Paul Giordano, Bob Tardif have really been involved in a number of initiatives, and I want to thank you so much. The Fort Myers Bar really does have a good reputation within the district, and in large part it's due because of the efforts and the work that those individuals and others put into working on these district-wide initiatives. So Judge Jennemann and I are happy to stick around, answer any questions. If you'd like to talk to Judge Jennemann with me out of the room, I'm happy to leave. But thank you all for being here this afternoon.